Hello everyone, this is the 225 Q&A practice. We're going to start off with plaintiff questioning. You're going to hear Santa Fe, doping, rehabilitated, violated, internal, revenue, reconcile, window, narcotics, Club Reno, Las Vegas, Nevada, holiday, federal, bookmaking, trafficking, betting, wager, and pardon. All right. And we'll go ahead and get started. Here we go. Ready? You have had occasion to go over this testimony with various law enforcement agents, haven't you? Yes, I have. Has it been pointed out to you that what you said at that time had to be false because the Holiday Inn didn't open until February of 2005? I don't remember that. So what you told the court and jury in the federal case as to time was false, wasn't it? I could have made a mistake, but it wasn't false. And you have a vivid memory, at least you pretended to, in front of the jury? Yes, I did. Now, going on beyond that point for a moment, were you always sure that this bookmaking operation was active in 2014 or earlier? It was in 2014 or earlier, yes. Well, did you ever think it was later? No, it wasn't. I am sure it wasn't later. Did you ever think it was 2015? No, it wasn't 2015. I know, but you said it was 2015 on another occasion, didn't you? I said approximately at that time. I wasn't sure of that. Well, you have always been clear on the fact that you went to work at the betting window at the Santa Fe racetrack in October 2014. That is correct. Well, now this matter involving trafficking of narcotics took place at an earlier time. Is that true? I don't remember that. Well, let's continue. You have been convicted of a felony of bookmaking yourself, have you not? Yes, I have received an unconditional pardon. Before the pardon, you were sentenced to the Nevada State Prison outside Las Vegas. Is that right? That's true. Did you serve time? Yes, I did. What was the nature of the bookmaking operation of which you were convicted? It was an operation that involved thousands of dollars. Where was the operation? At the Club Reno in downtown Las Vegas. Now, the reason I ask you about that is that you swore 3 months ago in federal court that you were never a bookmaker, didn't you? That's correct. I see. Let me ask you how you reconcile in your mind this statement you made to the grand jury in this case. I was the biggest bookmaker in Nevada. I said that. Now, earlier in federal court, you had been convicted of selling narcotics, hadn't you? It was painkillers containing morphine. Okay, then in 2009, you invented a substance containing narcotics for doping horses. That is not true. And what year did you receive your pardon? 2012. Now, to quote directly from the first trial of this case in federal court, when mentioning the pardon to the jury, you said I was completely rehabilitated. I don't remember saying that, no. You were pardoned. You never again violated the law. You deserved a pardon. Is that it? Yes. Okay, now what was the year you received that pardon again? 2012. And within a very short time, as you described this morning, you were passing bribes to public officials, weren't you? Yes, I was. By 2013, you were making large bets, weren't you? $10,000 a day? It was like $20,000 to $30,000 a day. At the same time that you were betting, were you informing the Internal Revenue Service as to the identity of the other bookmakers you did business with? No, not necessarily. Did you give the names of all the bookmakers? Most of them, yes. You said most of them. What does that mean? What? Did you withhold information and names? No, I did not. All right. We will switch transcripts. And this one is going to start off with plaintiff as well. You're going to hear restraints, suicide, facility, Jackson, institutions, etc., 4-point, suicidal, pre-warned, safeguard, scarves, sporadic, documentation, Ray Dalton, Maine, Banger, Kelly, and Portland. All right, and again, this will be plaintiff attorney. Mr. Kelly, you are not an attendant at the Portland State Hospital located in Portland, Maine, are you not? Or are you? Yes, I am. Oh, okay. Now on June 3rd, 2007 was a patient by the name of Scott Dalton Transferred to your facility from the Bangor State Care Facility? Yes, that is correct. Did documentation accompany Mr. Dalton suggesting that he might be suicidal or possibly suicidal? Yes, there was some paperwork that came in with Mr. Dalton to that effect. We had also been pre-warned as to his condition. Okay, what is the normal procedure in most institutions of this nature to safeguard a person of this nature from himself? We check the person for any weapons, sharp objects, belts, scarves, etc. that can be used in a manner to inflict harm to themselves. Are they thoroughly examined? Yes, we conduct a no-clothes search, sometimes called a skin search. Was this examination performed on Mr. Dalton? Yes, it was. Then what happened? Because of the sporadic behavior at the time of the arrival of Mr. Dalton at the Portland facility, the floor supervisor decided to put him into 4-point restraints. Is that the common medical way of safeguarding an individual from himself? Sometimes it is. Was there a supervising doctor on duty at that time? Yes, there was. Did he examine Mr. Dalton at the time he entered the facility? No, he was attending to other patients and wasn't expected to see Mr. Dalton until the following morning. So in other words, to protect Mr. Dalton from himself, he was placed in 4-point restraints? Yes, he was. Mr. Kelly, how long have you worked at the Portland State Hospital? 5 years and about 3 months. In your 5 years at the facility, what other methods have you administered to calm an individual down to eliminate the risk of suicide? Normally, we use one of 2 methods. The most common method is to place a person in isolation. We take everything away that they might use to inflict harm. Sometimes we put them into padded cells. Is medication ever administered to calm down individuals? Very infrequently. How infrequently? 1 out of 5 patients, 1 out of 100 patients, 1 out of 1,000 patients? I don't know. We would have to check the hospital records. Are all persons whose behavior you would characterize as sporadic put into 4-point restraints? Not always, but there was no doctor immediately available. Who makes the determination to put a person in 4-point restraints? Normally the doctor. Who made the determination to put Mr. Dalton in restraints? The floor supervisor, Mrs. Jackson. Where was Mr. Dalton taken to after he was put in 4-point restraints? To cell 11A. Was Mr. Dalton examined by a physician that day, June 3rd, 2007? No, he wasn't. What time did Mr. Dalton enter the Portland State Hospital? I believe at about 1:25 p.m. So Mr. Dalton was put in 4-point restraints on June 3rd, 2007, placed in cell 11A, and left there for over 18 hours. Is that correct? What do you mean by left there? He was left there unattended for 18 hours? No, that is not true. He was checked every hour on the hour by a floor attendant. Okay. So again, we will switch transcripts. This is a court format. And defense will be questioning. Here we go. Now, in fact, when they pay you overtime, they note it on your pay stub, don't they, Mr. Netter? Yes, they do. And in fact, these pay stubs don't say overtime, do they? Those 2 particular ones? That's correct. I'm sorry, I didn't. May I approach again, Your Honor? Yes. No, these 2 don't indicate any overtime on these 2. They're not consecutive. They are a month apart. Mr. Netter, in July, year to date, your earnings were $84,025.50, while in June, the same date, actually less than 30 days before that time, the earnings were $79,819.72. Now, I calculate that earning period in that 30 days to be $4,205.78. Now, can you explain to me how you calculate $3,200 from what we can see here in a 30-day period as being $4,205? I'm just assuming that was overtime for that period. And yet it doesn't say that on these pay stubs, does it? I don't get your point. Well, in fact, you didn't work any overtime during that pay period because if you had worked overtime, it would have shown on your pay stubs. Is that correct? These are missing pay stubs there. Well, these are 2 pay stubs, a month apart. Okay, so you're saying that there's some intervening weeks? There may be intervening weeks there. Did you provide those pay stubs for the court? I don't recall. What time do you leave for work in the morning, Mr. Netter? It varies anywhere from, if I have a departmental meeting, I have to be there at 8 o'clock. So I would leave approximately 6:15. My normal hours are 9:30 to 5:30, so I normally leave anywhere from approximately, by the time I drop Katie off, I leave the house about 7, drop her off about 7:15-ish. I'm usually on the road about 7:30. What time do you typically arrive home in the evenings? That varies also depending on what transpires during the day, and if I have to stay a little late. My normal hours are again until 5:30. I can leave anywhere from 5 o'clock to sometimes I work through the night, depending on what the circumstances are. How often do you work through the night, Mr. Netter? I'd say the last 6 months, there have probably been maybe, well, I'm not saying over. If I say overnight, I mean typically I can work until 11 or 12, and sometimes I work until 2 in the morning. Sometimes I work only until 9. So actually overnight, I've only maybe worked like maybe once or twice over the last year, but I have worked late where I have contacted my sitter and asked her to keep her overnight approximately 5 times. And how often do you get her home, or how often do you get home after 6 o'clock in the evening in a typical week? After 6 o'clock, it is in a typical, well, I take it on a longer standpoint. I'm normally always, you never say always, never say never type of idea, but I would say that my normal time is after 6 o'clock. And there would be a few days that I'd leave work early and pick Katie up early, or tell the sitter, don't pick her up and I'll get her. But it's after 6 o'clock. What is the latest hour that you, on a fairly typical basis, pick her up? Is that before 8 or after 8? Oh, it's almost never after 8 o'clock. I always have her well before that. Usually between, even if I'm late, it's between, 7 and 7:30. Have you made any efforts, Mr. Netter, to try to look for employment in the Riverside area so that you could be closer to your daughter? There are no major, with the exception of one, I'm in a bankruptcy department now, and there is no major bankruptcy firm that I could transfer to. The question is, have you looked for any employment here in this Riverside area so that you could be closer to your daughter? As a matter of fact, when I first moved here to Riverside County, yes, I did, but over the last year and a half, 2 years, no, I have not. When did you first move to Riverside County? Oh, it was in September of 2008 when we purchased our house. So you haven't looked for work in 3 years? Like I said, when we first came here to Moreno Valley, yes, I did. But over the last year and a half, no, I have not. Have you made any effort, Mr. Netter, to try to take some of this work home so that you could spend a little more time with your daughter? Objection, Your Honor. Objection. Sustained. Irrelevant. Okay, this isn't an issue of custody or visitation. No, I know, Your Honor, this is an issue of the amount of child care expenses that Mr. Netter is incurring. We believe that it's an unreasonable amount, and we believe that he's entitled to child care expenses, but only those that are reasonably necessary for his employment. And if someone is a paralegal working in a large firm in Los Angeles, residing in Riverside County, and they have to leave home at 7 and get home at 7 to 8 o'clock to pick up their child, I find that personally very burdensome. I doubt if he's going to be doing that because he wants to. He's doing that, from what I hear, because he wants to maintain an 8-hour-a-day job with a major law firm in Los Angeles. Now, is that reasonable or unreasonable from your perspective? Obviously it is. From my perspective, trying to be neutral and impartial, by no stretch is it unreasonable. Now, you may proceed with another line of questioning. Thank you, Your Honor. All right, and that concludes our 225 Q&A practice.